Madam Chief Justice, may it please the Court, my name is Tatiana Fountain, and I will be representing the petitioners in this matter. I'd like to ask permission of the Court to reserve 2 minutes for rebuttal. Maria's actions were protected by the First Amendment for 2 reasons. 1, her tuxedo does constitute symbolic speech, and 2, she did not cause a material or substantial disruption. This Court articulated in Spence a test for whether something is considered symbolic speech. It must first intend to convey a particularized message, and second, be likely to be understood by others. Maria's actions did have a particularized message, which was solidarity with Amber Green. Ms. Andrews made 2 speeches 14 days after finding out Amber Green's omission from the yearbook. In one of those speeches, she had held up a yearbook and stated that it is a great place for most students to go to school, but not all, resembling something Miss Green had said after finding out she was omitted from the yearbook. Ms. Andrews also started wearing her tuxedo within 20 days of finding out Amber Green's omission from the yearbook. She wore it consecutively for 5 days a week, and on the first day there was no disruption at all. Ms. Andrews clearly intended to convey a particularized message, which is solidarity with Amber Green.
Counselor, but would you say that her message was understood by the intended audience?
Yes. Only one student had asked Ms. Andrews what her message was, which was Walter MacArthur. She had replied, "Isn't it obvious?" Because the whole school, out of the whole school, he was the only student to ask what she was doing. He was the only one who did not understand. Students.
Well, how do we know that? I mean, we know that she's the only one who asked, but how do we know that everybody else did understand anything?
Several students had known about the omission from the yearbook because several students had seen the yearbook ahead of time. Only since Walter MacArthur was the only one to ask and the only one to really question it, Ms. Andrews understood that others knew what her message was. I mean, she wore the tuxedo, resembling Amber Green's omission from the yearbook for wearing a tuxedo. Her whole campaign for her presidential candidacy was inspired by Amber Green's omission from the yearbook. She resembled her when making her speech to the entire school.
But Counselor, wasn't the flyer that she used in her campaign double-sided, and on one side there was an advertisement for a tuxedo, renting a tuxedo?
Yes, there was. And that was to grasp the attention of students. It was prom season, they saw that, and it got their attention. It also got their attention to the other side, which had her see the big picture platform for her campaign that was inspired by Amber Green. Ms. Andrews did intend to convey a particularized message, which was likely to be understood by others, since only one student had to ask, and many students knew about the omission from the yearbook. It was understood what her message was, and students didn't need to ask. Ms. Andrews' actions constitute symbolic speech, and the only way that symbolic speech can be limited is if there is a material and substantial disruption, which this Court decided in Tinker. Ms. Andrews did not cause a material or substantial disruption.
What's material or substantial?
It is an actual or evidence of a future disruption.
Well, wasn't there an actual disruption here?
No, not an actual. Substantial is a bigger scale, something that's not normal. And in Maria's case, there was a minimal disruption of a passing of a note that happens common at high schools, especially in this generation.
Is there any case that's ever talked about how much of a disruption there has to be?
Yes, in Tinker it says there has to be an actual or a material or a substantial disruption, which is on a larger scale. They were afraid that there would be a disruption, yet there had not been a disruption in that case.
Weren't there cases where any disruption has been found to be enough?
Yes, in Blackwell, there had been a disruption.
And shouldn't we follow that?
No.
Because?
In this case, there was not a disruption.
Well, there was in the classroom, wasn't there?
It's a minimal disruption of passing a note. Passing a note happens every day. If you are going to consider one note passed a disruption, then all the students should be suspended from school.
So, in counsel, what would make this a substantial disruption? What would make the facts be different?
Had the whole educational process been halted, had she violated school rules, had she caused a riot, those are things that are substantial disruptions. Those are things that, the teacher really had to take a lot of time to control the class, which in Maria's case, there wasn't. She had passed the note. The teacher addressed the note, and that was it.
So then this court has to second guess the teachers and the school administrators about what's a significant disruption. Is that right?
I'm sorry, rephrase?
Well, shouldn't the school administrators be able to determine for themselves enough of a disruption is a disruption? We should come here a couple of years later and decide that, no, you were wrong, this was a disruption, but it wasn't enough?
I'm sorry, I still don't.
Well, shouldn't the school administrators, if they believe there's a disruption, shouldn't that be sufficient?
No, not in this case, because sometimes during the moment, the teachers are just caught up and they take it more personally, and that they're trying to control the class, or they're trying to teach, and the student passes a note and they feel almost disrespected. And had Mr. Alvarez watched this, had it been videotaped and he watched it, he would have seen that he overreacted a little bit in addressing the whole class. There was not material or substantial disruption. Maria had done nothing wrong. She had done something wrong in passing the note, but nothing wrong that doesn't happen in a classroom daily.
Wasn't there a suspected fear that this would interfere with the AP reviews that were coming up, the testing?
Yes. However, the school scheduled the candidacy to happen at the same time as AP reviews. By scheduling the candidacy, they knew that there was going to be commotion, there would be distractions, if you will. And so they took that risk. But Marie Andrews did nothing wrong. She didn't speak out, she didn't, run around. She had just simply gone to class as she was supposed to. The school clearly acted in undifferentiated fear because Principal Belding spoke to Maria once on Friday. That one time he spoke to her, he had suspended her. There was no warning for Maria, and for these reasons, she did intend to convey a particularized message that was likely to be understood by others, and she did not cause a material or substantial disruption.
Does there have to be a warning?
There should be. You can't suspend a student the first time they do something wrong. They should be told that. They should be given a warning,
Where does it say that?
You can't suspend a student the first time without any kind of address. It didn't say in the school year, it didn't say in the handbook that a student can't wear a tuxedo to school. Thank you.